All rise. Court is open. Please be seated.
All right, our next case will be number 23P380, RC versus CC. This is an impounded case, so I'm sure, as Ms. Rogers, I'm sure you know, we won't use names, and we will hear your argument.
Thank you, Your Honor. Members of the panel, may it please the court. Good morning. My name is Flannery Rogers on behalf of CC, the appellant. The plaintiff in this case is the defendant's mother. The plaintiff sought an abuse prevention order after she and her daughter had an early morning argument over the placement of a drying rack on which the defendant was drying her clothes. The plaintiff went to move the drying rack. The defendant objected, and the defendant pushed the plaintiff, who then fell into the drying rack and onto a pile of bedding that was on the floor. So the plaintiff in her complaint alleged that she was suffering from abuse under 2 of the 3 statutory definitions of abuse. First, she alleged that under 1A, the defendant had caused her physical harm, and second, under 1B, the defendant had caused her to place her in fear of imminent serious physical harm.
So let's talk about the first one,
Yes.
Section A.
Yes.
Why, well, it seems like your brief implies, it doesn't come right out and say it, but implies that physical harm has to equal some type of injury. Where do you have any legal support that there has to be some type of injury for there to be, quote, physical harm?
I think that the case law does make a distinction between a touching or some kind of physical contact and physical harm. I wouldn't go so far as to say there necessarily needs to be an injury in the sense of some grievous bodily harm or anything of that sort, but I would cite both Wooldridge v. Hickey and Simkowski v. Simkowski cases out of this court for the proposition that there is a distinction under Chapter 209A. And both cases have fairly similar factual patterns. In Wooldridge, the plaintiff, a woman, sought an abuse prevention order on behalf of herself and her children as against her ex-husband. The court really looked to the evidence with respect to the children. The evidence of abuse was that when the father, the defendant, was angry, he hit and grabbed his son.
And didn't that case sort of talk about a right for a parent to discipline the child?
There were citations in that case.
So in a sense, the court was saying the touching that was done in this case, and I think there's actually a phrase that said it may not have been good parenting, but was sort of saying there was some legal justification for that type of touching. In that case, it would be parenting. Maybe in another case, it would be, again, a self-defense argument. Obviously, you can push somebody as defense, so a legal justification for the touching.
So I'm going to push back a little bit, Your Honor, on that, because I think that
No pun intended on the pushing back.
Pardon. I think there has to be a distinction between the phrase physical harm in Chapter 209A and what we might strictly construe as an assault and battery or a sense of assault and battery under Section 13 and 265. And I think that's first because the legislature wrote physical harm as opposed to assault or assault and battery. And secondly, I think the case law over and over again has said that the purpose of Chapter 209A is to protect victims against the devastating impact of domestic violence. And one of the key phrases in all of that is that violence. So just to return to those 2 cases, Wooldridge and Simkowski, with respect to the situation, the circumstances of those cases, the parent and the child, I think that is absolutely a relevant factor that courts should look at. They should look to the circumstances of the relationship between the parties. But I do not agree that Simkowski says as a matter of law that when there is a parent and minor child relationship, that there is a different sort of statutory definition of abuse. I don't think that's
So in a domestic violence situation, you have, I'm going to give you a hypothetical, husband and wife have an argument, and during the argument, husband push his wife into a drying rack. That's clearly an assault and battery under the law. No legal justification, no self-defense. Person is charged with a crime of assault and battery, husband. That is not enough for the wife to get a restraining order? That's all the facts. Nothing about anything beforehand.
Yeah.
Argument, push.
I think that that is not enough, Judge. And I would distinguish a pretty recent case of CRS. Now I'm worried this is CMS, I'm sorry. CRS v. JMS. It's a fairly recent case, and the facts of that case with respect to the physical touching are fairly analogous. There, the plaintiff, the wife, alleged that her husband had pushed her into a wall on 2 occasions. Now, I would, maybe splitting hairs, but I would make a distinction between pushing someone into a wall, an object that is stationary, and pushing someone's, perhaps even by accident, so that they fell into a pile of bedding. But that aside, the physical touchings were that the defendant, the husband, pushed his wife into the wall. The court also looked at the relationship, the broader relationship, and the words that the husband had used, his behavior, how he comported himself, and found that there was this history of threats. There was this history of controlling behavior, of emotional and verbal abuse. Now,
So we don't have that here?
We do not have that here, Judge.
Can I ask, so is it your position as a matter of law that at the moment the judge is hearing the evidence and making this decision, that the question, the preponderance of the evidence regarding a substantial likelihood of immediate danger of abuse is forward-thinking? Is that what it is? So in other words, or can simply the occurrence of abuse in the relatively recent past be sufficient for the judge to just issue the order based on that?
So, first, I would just note that this was a 2-party hearing.
Yes, no, I know.
So-
And I know I'm going from the ex parte, but it's because,
It's similar.
it's because I think the standard when you have a first-time in 2-party hearing, it's a little bit, it becomes it overlaps a bit,
Yes.
right?
So yes, to answer your question, I think that Chapter 209A is forward-thinking, and that's in the statutory language, that it is a protective measure. It is to protect someone. And I think the word victim is, in a sense, appropriate here, because the implication is that there has been past conduct that would allow a court to infer that future violence is likely. And whether that be past physical harm or I'm not remembering the name of the case. Oh, I'm sorry. For instance, like Callahan v. Callahan, where the conduct was a bit in the past, but it was really significant. It was really significant and very dangerous, and that is absolutely reasonable to infer that such conduct could happen again in the future. I sort of hesitate to bring this up because the 3 definitions, they're distinct. I do think that they have a common purpose in the sense of protecting from future violence. In Callahan v. Callahan, that the abuse, the initial order and the extension order was based on physical harm, on Section 1A. That case has been cited in a 2020 appeals court case, Yana Y. v. Sylvester S. And that was abuse. That was an order to protect from abuse under Section 1C. Past sexual harm, sexual violence, and what both of those cases stand for is that past harm can result in such damage to the plaintiff that future orders would be appropriate, even if there's not a huge significant likelihood that violence might happen again.
As a sort of a side issue, you have not raised it, and I assume you're not arguing that, deference to the judge and the circumstance that she was in, but there was a rather perfunctory pass at the right to testify as opposed to the Fifth Amendment privilege in this case, and it was in spite of the fact that she had an imminently impending arraignment prior to appointing counsel who couldn't necessarily represent her on the restraining order, but could certainly advise him, your client, or no, it was her, as to whether and to what extent she ought to invoke her Fifth Amendment privilege or not. There was none of that, it was, right? But you're not, that's not something you're
Yeah, I was not
pressing here.
present at that hearing. I did listen to the FTR, and what is marked as probation in the transcript is actually my supervisor, Suzanne Raposa, who is a CPCS attorney.
Thank you for clarifying that. That
I
seemed a little odd.
I
All right.
suspect that Attorney Raposa was standing at the lockup,
Okay.
next to CC
Makes sense then.
at that time.
Okay. Thank you for filling that gap.
And we could hold it an inference against her for not testifying. I don't know what that inference would be, and frankly, I don't know if we need to go down there. But let me ask you this. Again, back to the definition of physical harm, because to me, at least as to that first prong, that's what it comes down to. You agree under 209A, there is no definition of what physical harm is. There's a definition of abuse, but there's no definition of physical harm.
I agree, Judge.
So if we go to the dictionary, which would be, I guess, our next step since there's nothing in the statute, physical harm includes, according to the dictionary, mental harm. Couldn't the judge have inferred, based on what the plaintiff said, that the surrounding circumstances of the daughter and her at least having arguments about certain things which are in the record, along with the push, not very forceful, but enough to cause her to fall back, is enough to cause a plaintiff, by a preponderance of the evidence, mental harm?
No, Judge, I would not agree with that statement. First, because I know that Larkin v. Air Division of the District Court Department has sort of, I would say it's dicta in that case, that that it's possible that emotional or verbal abuse could manifest physical harm. To my knowledge, there's been no case that's actually adopted that proposition as a rule of law.
So if you had to write this decision, what would your definition of, quote, physical harm be? Because it seems like that's what you think the judge should have followed.
Yeah, I guess I would hesitate to imply that there needs to be a strict definition of physical harm, because I am cognizant that that a district court judge has discretion to consider the entire circumstances of a party's relationship.
I want to just use these circumstances, which
all right,
frankly
Judge,
are not
yes.
that uncommon in the
Yes.
district court. There's an argument and there's a push. How forceful does the push have to be? Does she have to fall against something?
Yes.
Does there have to be injury? What
Yes.
would you suggest is enough by a preponderance?
In this instance, Justice D'Angelo?
Sure.
It's not enough, and the reason it's not enough is because the plaintiff did not testify to suffering any harm from the push and the subsequent fall.
But wouldn't it be a reasonable inference? I mean, even if she didn't say, "I was harmed," there's no indication that this wasn't an intentional push. I mean, it's not portrayed as an accident.
Not by the mother's testimony, yes, correct.
Right. And so can't we infer that there was at least an attempt to cause physical harm?
I mean, I would respond to that, Justice Sachs, that it's the plaintiff's burden to establish by preponderance of the evidence the facts necessary to find abuse.
But the facts are that there was a push, enough to push her off her balance and hit the cart, the laundry cart. Why couldn't the judge infer from that fact that there was an attempt to cause physical harm, even though through a fortuity she fell onto some blankets and pillows rather than on the floor or some other hard surface?
I think that even, I suppose the judge could infer such a thing. I still would argue that that's insufficient to establish abuse under Chapter 209A, and I think that
So can I ask you, I'm sorry, I don't mean to keep interrupting, but can I ask you on that? So if we can all agree that this is a close case, that one judge in this courtroom might go one way and another judge could conceivably go a different way on any given day, then how do we reach this as a matter of law, that this set of facts is insufficient to establish either attempting to cause or causing physical harm?
with respect to Justice Brennan, I actually don't think it's a close case, and I say that because the follow-up question to this testimony was whether there was any other abusive behavior, and the rendition that the plaintiff provided to the judge was simply not behavior that constitutes abuse under the statute, nor is it behavior or conduct that could give rise to an inference of threatening language or violent or future violence, and I would just note that the law and the case law has made it clear that 209A is not intended to be a catch-all for general family relationships, and I think the relationship that the plaintiff described here was a maybe unfortunately typical relationship sometimes in multi-generational households where there's a lot, there's not the typical or traditional division of labor. That kind of division of labor needs to be negotiated, and when and that can cause rift. And just to conclude, Your Honors, I want to make clear that I'm not challenging any credibility determinations here. My argument, CC's argument, is that on the face of the testimony, it's insufficient to find abuse under 1A or 1B, and that the order should be vacated. Thank you, Your Honors.
All right, thank you very much for your very capable argument and well-briefed case, and we'll take it under advisement.
Thank you, Judge. Thank you, Your Honor.
Our next case is number 22P564, John Doe, number 242548 versus Sex Offender Registry Board. And as I'm sure both counsel know, but just as a reminder, the case is impounded and we won't use any names. Ms. Doherty, whenever you're ready, yes, take your time, get some water.
Thank you. Sorry for the delay.
No problem.
Good morning, members of the panel. May it please the court. My name is Elizabeth Doherty. I am the counsel for the petitioner in this case, John Doe. Just as a brief introduction, the petitioner in this case, who from the record of the hearing and other documents, you can tell his command of the English language was limited, as well as his command of the proceedings was limited. But actually, before the proceedings actually took place, he made a request of the hearing examiner that he have a new attorney, and that the hearing examiner did not inquire into that.
Counsel, I'm going to, thank you. There may have been a waiver at the hearing, but the language may have explained it, and I'm going to let you go further on that if one of my other colleagues has a question. However, it wasn't raised either at the Superior Court. So why isn't there a waiver of that entire issue because the Superior Court judge didn't have any of that information?
That's correct, and that is, of course, the elephant in the room, and I was going to get into that. I can either respond to that or I can respond to Justice Brennan.
Oh, that was my question.
I have a question that might come before that logically or might come
right
after,
ahead.
but I'll ask it and you decide which one to answer.
Okay.
Let's assume that the issue had been preserved and that he was denied his request to change counsel. What is the prejudice? What has been shown on the record that would have happened differently, or what different strategy would he have followed, or different evidence would he have introduced if he had different counsel?
Well, the prejudice would have been substantial, and I believe the record shows that quite clearly. The indications were that he had an entirely different strategy from his counsel, and that's clear from that. In fact,
Which was?
well, it appears that he had evidence to present.
What evidence?
I'm not sure he wasn't able to present that through his attorney. He also wanted to testify. That was foreclosed for a couple of reasons. In fact, his own attorney objected to him making a statement. So I think the prejudice was that he proceeded into a proceeding without an attorney who had his best interest in heart. What I was going
Can I ask you just,
Sure.
where is the clearest indication that your client wanted to testify as opposed to comment, pontificate, make editorial statements of things of that nature?
Well-
There's a difference, right?
Well,
Because it would have been out of order before the proceeding even started.
Yes.
He wants to talk. So that's different from wanting to testify. Would you agree?
Well, I mean, I think sort of stepping to the side of all of this, and I think this is sort of an overarching theme of all of this, is this was a petitioner who needed the assistance of his attorney to present the case in the way in which he saw it fit. And that was, he was thwarted right from the get-go, right from the beginning. He was not able to present a case that it is his case that.
I guess my point is in the record, how do we know that? Where do we see
Well,
that?
Later on, he says, this is in the transcript of the hearing, he says, well, let's see. I do have it highlighted. He says, his attorney says, I'm not planning on calling him as a witness. At one point, he says, I'm going to object to everything that he says.
But once he had new counsel in Superior Court, couldn't new counsel have filed a motion to take additional evidence before the board, saying, here's how my client was prejudiced by what prior counsel did?
He could have, and again, that sort of segues into the waiver. And obviously, I'm not able to state that it was brought up in the Superior Court, but I would argue that the record here does show that he wanted an attorney, he wanted a new attorney.
I'm not so sure the record is that clear, counsel. Again, I try to give deference to somebody who has a language barrier. I wasn't sure, based on what he was saying through the interpreter, that he even knew that was his lawyer. He doesn't say, I want new counsel, I don't like this guy. He just says, I want a lawyer.
He does not, and I certainly have to, I believe that the record, if you look at it, does establish that. But that's where it comes into where I have to put some of the a great deal of responsibility on the part of the hearing examiner, who
Let me ask you though, when the hearing examiner says, then why don't you give them an opportunity to talk privately? Wouldn't it be then at that point that the lawyer would come back and say, oh, okay, my client is dissatisfied with my representation. My client doesn't like the strategy I'm employing. That's why you give folks an opportunity to talk privately if you're the examiner or the judge, so that you can get a sense of what the issue is. And
well, in fact,
go ahead.
In fact, that happens twice, which the board points out, in that there were two instances where it was adjourned. After the first one is when he comes back and says, I need an attorney. They step aside or whatever and go off the record. And at that point, he comes back and says, I need an attorney. He does not, I will give you that he does not say, I need a new attorney. But again, this is where I think it was incumbent on the hearing examiner to have a searching colloquy, a searching inquiry of the petitioner and counsel to find out. That never happens. At one point, the hearing examiner says, when he says, I need an attorney, the hearing examiner says, well, you have an attorney. Let me clarify. There is never any clarification. Again, they come back after that, and the hearing examiner doesn't inquire as to the nature of the problems or whatever, just sort of lets it slide. And then at that point, soon after that, is when you have the exchange from the hearing counsel who says, I'm going to object to what he says. I don't want him to, I don't want him to make any statements. I wasn't planning on calling. Clearly indicating, and again, I appreciate that the record, given the deficiency of language on the part of the petitioner, it is lacking. It's not the clearest record of all. But I think the indications are there that you have a petitioner whose interests are not aligned with his counsel, and at the very least.
Attorney Green, you will agree, though, and I'm not saying we weren't there, but your client speaks pretty clear English and says, in fact, he says at one point, oh, I can speak it pretty well. I just want an attorney because understanding sometimes is difficult, and or he says, I understand it very well, but sometimes in this context, I might want something more. So it's not as if he...
It does seem at that point, but
Right.
that's sort of compounded by, a lack of understanding of what's going on, which sort of segues into when they wanted him to swear and he doesn't want to do that. That could have been avoided had, A, his attorney stepped in and explained to him how affirming is one of the statutory measures set up to protect people's religious convictions. That didn't happen. The hearing examiner didn't step in to do that at all.
Tell me, again, I know you think it's clear. How do we just ignore the fact that this wasn't brought up to the Superior Court? Because the Superior Court judge, in many cases, ones that we don't see, remands the case back because of these deficiencies. And that's why there's a Superior Court review. There's no issue of ineffective assistance of counsel. There's no issue of the language barrier brought before the Superior Court. How do we just ignore the waiver issue?
Again, I'm not able to establish that, or I'm not able to show in any way that it was brought up before the Superior Court. But as I think I got into in my reply brief, by treating this as the usual case in which there was waiver, we treat the deprivation of counsel, which is treated uniquely in civil proceedings and criminal proceedings, we treat that the same, when in fact it's the right that from which all other rights emanate. It's the right, and I think I quoted Chief Justice Roberts' statements in Cayley versus United States. It's the most important right because that's the right, that by having the right of counsel, you have an attorney who's going to fight for you to preserve those other rights. And I would submit that that's what happened here.
But even once you put in an appearance in the case, it was within a year after the court's decision on the merits, the Superior Court. Wouldn't it have been possible to file a Rule 60B motion along with an affidavit from Mr. Doe saying, here's why I was dissatisfied with my attorney, here's the evidence that I would have put in or the testimony that I would have given had I been allowed to, something so that we have some notion of what the prejudice was?
I suppose that's correct, that could have happened. I do believe, though, that the record here, when you look at it, is sufficient to show that happened. And we are not asking that the classification be, that the different classification be at issue. More what we are asking is that the case be remanded for another hearing.
Let me ask this, on the remand, because the Superior Court judge did remand it so that the hearing examiner could consider the SDP reports, right? Mm-hmm. And you argue that on that remand, the hearing examiner failed to adequately consider the reports. How do we reach that conclusion? Isn't that a weighing? Isn't that a...
Prior to Doe 11204, it might have been, but I believe that this, and I will submit that I think both of the hearing proceedings preceded Doe, which came out in 2020. But the case is pending, so it still would apply to that. But I think it's much on point. I know the board states that it shouldn't be considered, and it's not dispositive, which certainly is what Doe 11204 says. I'm quite impressed with myself that I can remember these numbers.
I'm sure.
The first case, I think I had like things written on my hands. in any event, while the ultimate risk determination is not dispositive and doesn't have to be considered, the evidence in those reports, which is what DOE 112 is, they're the same issue that's to be considered. And the hearing examiner, excuse me, just dismissed them, saying like, well, SGP and SORB are different. And that's exactly what this case has held.
I want to ask you about the 2017 static 99R scoring. You say in your brief that it was improperly scored. You have a citation to some scoring manual that may or may not appear somewhere on the internet for the static 99R. But assuming the issue is preserved, how can we tell whether the improper scoring of the individual components of the test actually affected the final result in any way that prejudiced your client?
That didn't help. I don't think we can. I mean, I think that's why it needs to be remanded for that. I don't think that we can. I think that, excuse me.
Take your time. You need a minute? Take your
I
time.
do, actually. I think that's better. Thank you for your patience. The manual that I referred to, I believe is in the record. That's
Static 99R
Yeah.
coding rules
yeah. I mean that's what.
by Phoenix.
Yeah. That's how all of the SORB all of the risk evaluations are done. So I think that is part of the record. But as I say, the error here is more that that they just disregarded information that is relevant to the determination, just out of hand.
Well, I can see that they disregarded the more recent static 99R scores.
Yes. Well, and not just.
At least the hearing examiner did not mention them.
Yes, I mean, and not just the determination, but there were a lot of fact-based determinations that were contained in the QE's reports. So that in and of itself is an error and warrants a remand.
Just to be clear, the item that you referred to in footnote 11 of your brief was the static 99R coding rules, the
Yes.
2016 revision. You think that's in the record somewhere?
I mean, I believe that it is. I would not stake my life on it. I believe that it is, but that is the manual that from which the coding rules. I mean, it's.
So we would have to score the static 99R ourselves in order to
Which is
determine.
what I did. I went through it and looked at it and said, well, this isn't right and that isn't right. I mean, I didn't include, and I certainly can supply that to the court if you would like that. I can supply that.
We'll
So
let
that
you
we
know
can
if
score it?
Well, so that you can see the.
Okay.
the-
Thank you.
It's not that difficult to score. I mean, it's definitely.
Nope.
So,
Sure it's not.
All right.
if there are no other questions?
Seeing none,
Thank
thank you
you.
for your argument. We'll hear from the board. Ms. Greenaway.
Thank you, Your Honor. May it please the court, Roxanne Greenaway for the board. I think one of the first things that Your Honors point out is the waiver argument. And the record that we have before us, putting aside what happened at the hearing specifically, when we get to the Superior Court, none of these issues are raised. You have a completely different attorney who actually files a motion for additional evidence, Your Honor, and the case goes back to the board. That would have been the appropriate time to raise this. What we don't have in this case, and let me just add, when you look at the Superior Court docket, it's on A696. You will see that in that particular case, Attorney Silverman filed a motion to withdraw, and then withdrew that motion, and then proceeded with the case. So this is an individual that has continued with representation after expressing that he's not, in some form, by the attorney filing that motion, that he's not pleased with the representation of counsel. Normally, what you have when you have a motion to withdraw, you could have some sort of affidavit that indicates, I didn't get to do this, therefore, even the affidavit of just Mr. Doe would be something that would indicate in the record that there's an issue.
Well, you would agree that a transcript where the John Doe's own lawyer says, I'm going to object to him testifying, that is kind of an inconsistent position when someone's own lawyer is saying, I'm going to object to what my client says.
Well,
how is that effective representation?
Well,
Or any representation,
yes
for that
and
matter?
no, because the law is that he can, if you look at the transcript, he's very clear that it is not his decision whether or not Mr. Doe testifies. You will see that throughout the entire record that Attorney DeFazio continues to represent him. We are here today because Attorney DeFazio followed through on that representation even after he left the hearing by filing that notice of appeal that brings us to the Superior Court.
So, are you suggesting that we should somehow then understand the attorney's objection to his client testifying as somehow indicating that if he's going to say something that's against my advice? Is that what he's saying, or is that too far a leap?
No, I think he's indicating that I am not trying to put him on as a witness. However, he wants to testify. Therefore, it is his decision whether or not he wants to do that.
Can you, putting aside the waiver issue, can you discuss the affirmation and oath
Sure.
question, please?
With regards to the affirmation and oath, what you have here is, and I just want to put on the record, because someone speaks a different language does not mean that they don't understand. What we have here is someone with a sworn Spanish interpreter that is there to assist them with the language barrier. And there is no indication in the record that the interpreter or the attorney, after private consultations with Mr. Doe, expressed anything untowards happening. Now, with regards to the oath, he indicates that when you look through the record, you will see that when the hearing examiner is trying to explain to him that in these proceedings, before you can make such a statement, there needs to be, in some form or fashion, some oath or affirmation with regards to what you're saying under the pains and penalties of perjury. He indicates that he understands. However, he is not going to do that because of his religion. Now, it is Mr. Doe's burden to articulate to that hearing examiner what that objection is.
Well, but doesn't the affirmation or oath, and this goes back to something Justice Brennan asked opposing counsel, that only applies when somebody's presenting evidence. You don't need to be under oath to make a statement, do you?
Well, let me give you this example. Representing Mr. Doe, and you're sitting next to him, and he wants to say something, and you have no idea if that's against his interest. It's your, and as board counsel, I would also say the same thing. He should speak to his counsel first.
He did.
Before making a
He
statement.
did.
And
He goes off the record, and then he speaks to his lawyer, and then he still wants to make a statement, which is his right, isn't it?
Correct, and his attorney.
And not a right that has to be under oath or affirmation, because we don't know whether he's going to be presenting evidence. He might just be saying, like your opposing counsel suggesting, I want a new lawyer, I can't go forward today.
But you don't have that evidence. What you have in the record is that the counsel indicates, I can't really tell what he's going to say.
Okay?
After assistance with a Spanish interpreter in private attorney-client conversations, he comes back to the hearing examiner and says, I don't know what he's going to say.
Couldn't the hearing examiner, instead of insisting on an oath, have said, okay, say whatever you want, but if you're offering evidence, I'm not going to consider it because it's not under oath. You're going to have to testify at the appropriate point in the hearing.
Well, I'm not going to second-guess what the hearing examiner...
Well, that's kind of our job.
I understand.
Not second-guess, but at
Right.
least review for abuse of discretion.
Oh, in this discretion, the hearing examiner, and you can see on the record, tried to indicate, I am confused as to what you're saying. I will give you an opportunity to make some other form of affirmation in order to speak, because everyone, as you can see from the transcript, does not know what he's about to say. Now, again,
But this is where I guess I'm calling that not correct. The hearing examiner says, you can't talk at all unless you get sworn in, and that's not accurate.
let me put it this way. In order for him to make certain statements, he is to be, and we don't know what that statement is. You do not know if it's testimonial in nature or what the nature of that statement is. In an abundance of caution, one should give that oath to make sure that all rights are preserved. Now, with regards to, when you look at the record, again, the hearing examiner gives him different opportunities to express and articulate what form of affirmation would be okay with him to proceed. Then, after the hearing examiner indicates that you cannot speak in this context, she then gives him the opportunity and says, well, after the hearing, you can certainly meet with your counsel, and if there is something that you want to express, you may do so.
Why isn't this good enough? And as an affirmation, he refuses to raise his hand, and this is on page 776 of the record appendix. When I say the truth, I'll say the truth. I don't have to lift my hand and swear because my blank. So I have something I want to explain, so if you're going to believe I can do nothing, just blank, I can't swear as to something personal. Why isn't that very first sentence, when I say the truth, I'll say the truth? That sounds like an affirmation, doesn't it?
Well,
There's no magic words to swear somebody
but in the
in.
normal course,
Yeah.
where you have oaths and affirmation, the person, there's an exchange. And if you look at the statute, at the regulations, it indicates that the hearing examiner is the one that's supposed to administer this oath or
Okay.
affirmation. Where you have the individual on the other side indicating that I'm not going to take an oath.
But that's not what he says, counsel.
If you look
The
on-
hearing examiner says, Mr. Vasquez, will you cooperate with holding your hand up, and I can say, do you affirm that you're going to tell the truth and nothing but the truth? Response, when I say the truth, I'll say the truth, but I'm not going to lift my hand. Why isn't that good enough?
That, if you look at the page before, it says, he says, I'm a Christian, I'm not going to do this oath.
Okay?
He specifically says that.
But an affirmation is permitted instead of an
Right,
oath.
so then the hearing examiner gives him an opportunity to affirm.
But she says, raise your hand and affirm. That's
And
the
raise your,
conflict.
and again, he does not, it is upon him to articulate what affirmation, and I understand the justice is indicating just by saying, I swear I'm going to tell the truth, that is an affirmation.
Isn't it?
I would not go so far as to say that
What is?
an affirmation.
You don't have to raise your hand. The law's
You don't
pretty
have to raise
clear.
your hand,
You
but
don't
you-
have to say, I swear to God. What you have to do is confirm, I believe the law says, that you will tell the truth. That's what affirm means. I affirm I'm going to tell the truth. And that's exactly what he says. When I say the truth, I'll say the truth.
And I will defer to
Of course, he
this.
doesn't say what he's going to say when he's not telling the truth, in fairness.
And I will, again, I will state this. The hearing examiner again gave him an opportunity for whatever it is that he had to say. He had an opportunity to put that in the record. post-hearing.
You're not suggesting, though, that as the examiner appears to be implying, if not stating affirmatively, that the affirmation or oath, whatever form it may take, requires raising your hand?
No, I am not.
Okay.
Not at all.
Do you disagree that that seems to be the impression that the examiner is giving in her statements?
I think it can be, that could be one way of reading it, that she's indicating.
What's the other way?
I'm sorry?
What's the other way
The other
of
way is that
reading,
they're-
will you
when I
hold
look
your
at
hand
it,
up?
They're in the process of fleshing out what it is he's trying to say, what form of affirmation is okay.
So your point is, he could say, no, I will not hold my hand up.
I'm
But
sorry?
you're saying the response could have been when she said, will you hold your hand up and allow me to ask you to affirm, during the course of that exchange, he could have said, well, no, I won't hold my hand up.
He could
but-
also say that, just like he said, I'm not going to take the oath.
Can I turn to a different issue?
Sure.
Which is the scores on the tests. The hearing examiner considered the 2017 scores on the static 99R and stable tests, but despite the remand to consider the QE reports, and despite the issue of the more recent scores being available having been raised, the hearing examiner did not mention those in her decision. Those 2019 static 99R tests both scored Doe as an average risk, whereas the more dated tests scored him as a high risk. So why isn't that in and of itself reason enough to remand?
I would say, first of all, that's harmless error. There is no prejudice shown in this case that the hearing examiner relied on the static 99R, even the 2017 scoring, in order to decide ultimately what his risk is and what his level of dangerousness is. The hearing examiner is clear that she's deferring, after a review of the hearing of the QE reports, that she's deferring to the board's factors and the application of the regulatory
Right, but
factors.
she discusses under Factor 35 that he was administered the static 99R and stable 2007 in 2017,
Correct.
and he scored high risk
risk.
on both. And the hearing examiner says, I consider this factor, but she didn't consider the more recent tests that gave him a lower risk.
And if you go on to look at that whole section, Your Honor, it's not only the static 99 that's in that factor. You look at the other parts of the QE reports where it indicates that the QE acknowledges that the QE's reviewed the previous assessments, his history, his records, in reviewing we would all like a bit more analysis.
The hearing examiner recites the fact that the QEs looked at his previous scores.
Correct.
The hearing examiner does not say, I've looked at his current scores.
I understand that. That is one, and again, I would indicate there is nothing to show that particular, not considering the 2019 static 99R results would change anything in this.
Is it possible that it may have affected the result?
No, and I would even go so far as say, when you look at prejudice in this particular case, if the case were to be remanded, first of all, he's eligible for reclassification, and he has been for months. That's number one.
Well, then there's some burden on him at reclassification. But persuade us that this may not have affected, could not have affected the final classification here.
When you look at the application of all the factors, again, I go back to saying that the hearing examiner looked at a comprehensive application of the factors in this particular case and not necessarily one factor. That one factor in and of itself is not dispositive of.
Wouldn't that ordinarily get a fair amount of weight as a matter of common sense? If someone has been scored on some tests which supposedly produce objective results and have some scientific validation, and they showed that he was a high risk, that kind of seems like an important factor.
Well, if you look at, I believe in the hearing examiner's decision, you will see a discussion that indicates that the static 99R, it is a result that they took into consideration, it's 2017, static 99R. But that is not dispositive. The hearing examiner does not cite that in any part of the record where it comes to making the decision as to what his risk is and what his level of dangerousness
So
is.
she considers it as factor number 35, but you're saying that didn't go into her ultimate decision?
No, I would say she considered it as part of factor 35 because there are other sections of factor 35 that she did look
Because she
at.
does mention it in her discussion section.
Correct. She looks
Record
at other
Appendix
things.
80.
I'm sorry?
Record Appendix 80. I'm sorry, not Record Appendix, the addendum to Mr. Doe's brief where the decision is reproduced. And incidentally, we do appreciate that the decision should be reproduced in the Record Appendix as well as the brief, just for future reference. We can find it in the brief, but under the rules, it's supposed to be in both places.
And again, when you look at the application, and I go back to I refer you to the substantial evidence portion of my brief, where it indicates what the balances of the factors and the overall assessment of this particular individual, why the hearing examiner came out. But again, there is no showing of prejudice. There is absolutely, much of these arguments should be waived, because in this particular record, you have a different counsel that you have in the record that he filed motions for additional evidence. You have evidence that the case was remanded for further consideration. And these are stuff that should have been raised at that juncture, so it could have been remedied if it was an issue. Now, the court certainly can take judicial notice of his cases that he's picked up post-hearing. And again, while it's not part of this record, there is absolutely, I'm confident that if this case were to be remanded, he would remain a level 3.
All right, we're going to have to leave it there unless there are any further questions, and seeing none. Thank you both for your arguments. And the final case we'll hear today is number 23P73, Brett Lyman versus Sasha Lancer. And it's going to be Mr. Cohen?
Yes. Good afternoon, Your Honors. May it please the Court. I'm Jeremy Cohen, and I represent Brett Lyman. We're trying to recover possession of Brett's dog, Teddy. I'm here as an advocate for pet owners' rights. We are not here to advocate for a change in the legal status of pets. We're just trying to restore what the Superior Court found, which was that Brett, Mr. Lyman, is a co-owner with Ms. Lancer of the dog Teddy.
That doesn't seem to be disputed. That Ms. Lancer has conceded that, I think, in her brief. The single justice recognized it. They're co-owners. So the question is, what are the rights between them?
Your Honor.
And how, if at all, can those rights be enforced at the preliminary injunction stage?
As we saw at the Superior Court, the finding that they planned that once, before, during, and after the relationship, if their relationship with each other ended, the relationship with Teddy would not. And even, in fact, for 6 months, they shared the dog Teddy. What happened here is that the single justice, she abused her discretion and made errors of law first.
So can I ask you about that? Because you seem to suggest that the judge, not the single justice, but the Superior Court judge did not treat Teddy as a person. But if you look at the findings, it says they have an express intent to share custody. They acted on an agreed and shared custody, and they agreed to mutually agreeable locations for the exchange. I mean, when we talk about custody, normally we're talking about human beings, yes?
Normally.
Okay.
Do you have any other example of any other custodial arrangement for real property? Yes, for personal property.
Oh, I'm sorry, personal property.
I do for personal property. So citing to Westford versus Nobrega, 411 Mass 798, 1992 case, these were two co-owners of a lottery ticket. And one co-owner sort of absconded with it, just happened to hit the number, and the court said, no, you have to share the winnings. There's equitable relief there for the person. We have not, in any of our briefs, ever referred to a dog as a person. We do not believe that they have the rights of a child.
Acknowledged, but I think what might have been concerning to the single justice from the use of the term custody, which was in the Superior Court judge's findings, is the notion that this agreement between them to share ownership and to have a 50-50 split of time is going to involve a bit of supervision by the Superior Court, because it's not that simple. It's going to involve ongoing involvement in determining the little disputes that come up about where is the exchange going to take place, when is it going to take place. If one of the parties held to the dog for a little longer one weekend, then how is that made up, if at all? And so it begins to resemble what probate and family courts have to do in child custody cases.
Understood.
And so that was a long wind-up to my question, which is, can specific enforcement of an agreement, particularly an agreement this kind of vague, it just says 50-50 split, that's really all we know about it, can that be done at the preliminary injunction stage? Is that the kind of appropriate use for a specific enforcement remedy?
It is, Your Honor, for a few reasons. One is, we're doing this. All over the Commonwealth, these orders are in place, either from a preliminary injunction stage before this appeal, or at the end of a trial on the merits. There are shared custody agreements being enforced around the Commonwealth.
That's not in the record, is it?
It is not in the record. But we would share that. We shared it with the Superior Court judge, where the enforcement, what these agreements actually provide, instead of needing enforcement, they provide a relief from the anxiety for pet owners who here are shown to both own the same piece of property, that when you don't have your dog, you don't have to worry anymore because the other person is supposed to deliver it up at a certain time and place, and the court is behind that.
Counsel, I'd like to ask a similar question to Justice Brennan, but I'm going to give you a very clear hypothetical.
Okay.
Two people jointly buy an antique car. There's a breakup of the parties, whatever the breakup may be. For the ownership of the car, do you have any case at all across the country where a judge can say, 1 week you have the antique car and another week you have the antique car because I find this to be such an unusual piece of property, I can't just give ownership to one party?
Well, we have cited to cases in the brief that all we're trying to do is dust off 200-year-old property law and have it apply to a modern-day property dispute, where sharing of ships and boats, going back to the 1800s, people could co-own or companies could co-own.
That wasn't sharing, as I read those cases. That was ordering a transfer, or in some cases enjoining a transfer, which is a one-time order. And it's a pretty clear black and white question whether the order has been complied with. Here, there's going to be ongoing supervision. The parties would be sharing the physical possession of teddy bear. How is that not going to drag the Superior Court into the same kinds of disputes that the probate court has jurisdiction of because the legislature said so? Here we don't have anything saying the Superior Court can do this.
Well, probate courts specifically won't entertain sharing agreements of dogs because they don't want to be overrun with these.
Right. But my point is they do this in the case of children for very important reasons pursuant to statutory authority.
Your Honor, I would ask...
Because the legislature wants probate courts to spend their time and the taxpayer resources on adjudicating those disputes in the best interest of the child. We don't have anything like that at the Superior Court level for dogs or cats or other pets.
We need it. And we need it because here are two people that have rights to the same property.
So can I say, I know we keep cutting off, but you say we need it, but you begin by saying you aren't here advocating for a change of the law. But why not? Why is it not time to have the law reflect current norms, which I suggest are that pets are not pure property?
And so, because we don't want to open the door to suddenly groups trying to say that pets have standing, that somehow they could bring actions on their own or through a guardian. The law that we go through here, especially Judge cites to Irwin, the single justice does, and so do we, because Irwin gives this court the permission to say, in Irwin, pets are special property, they are unique, and they have to be considered different. And in that case, they decide that's the first step to considering them as different type of property.
Is the answer to my question no? That you don't have a single case from across the country where a piece of property, real property, there's shared, I'm going to use the word custody. 1 week you have the car, 1 week you have the car, and we swap like that forever?
I do, Your Honor.
What is that?
Again, it's for personal property, and it's Houseman v. Dare, and we cite this case. It's a New Jersey case, 405 NJ Super 538.
It was a final decision in which the plaintiff, Ms. Houseman, I think, was awarded the permanent possession of the dog. I didn't see that as sharing and trading possession or custody or whatever you want to call it over time.
In my reading of it, I thought that after it came out of probate court and went to the higher court in New Jersey, it's the same fact pattern as we have here. And I believe that they recognized that they both had rights to share. Perhaps I'm not recognizing the holding for what it truly is. But the further issues here are, the single justice said that a specific performance of something like this could never apply to, could apply to real estate only, not to personal property. That's simply not the state of the law. Clark v. Flynn says that you can.
Didn't quite say that. The single justice did allude to, I don't see where the single justice said this could never be done as to personal property. If I'm missing something, or maybe you could point it out to us.
Well, I felt that under 231, Section 18, that she went beyond the scope of just looking at what the Superior Court judge had before her to issue the preliminary injunction. The single justice also went on to say you can't have specific performance for an oral agreement for personal property, which the case law, again, does not support. TFVBL, Summerby versus Bunton. So I felt that the single justice was going out of her way to find reasons not to apply this when the law is already giving us the permission to do it. Also, under 214, Section 3, the power of the Superior Court Justice specifically says to do all things regarding personal property and the division and ownership and distribution of that. And that's all that the Superior Court judge was doing.
Can you point to the specific words in 214.3.3 that go beyond ownership and division of the proceeds of sale to authorize ongoing sharing of possession? Because I didn't see that.
It doesn't say sharing, but it says to do all things related to personal property. It specifically says the recovery of chattel.
If we look at the words, to order a division or sale thereof, meaning personal property, make an order a proper distribution of the proceeds of a sale, and to do all other things relative to a determination of the ownership, division, and distribution of such property. I don't see where you're asking to determine ownership, division, or distribution. You're asking for possession to be shared.
Which I believe is division of the property, of the personal property.
Well, division would sound like something that Solomon would have ordered.
And we hear that.
Neither party is asking for.
Your Honors, what are we supposed to do in this situation where the parties recognize they both own it, they both had the intention to share afterwards, and we get to this point where suddenly my client has no remedy at law because it's not been done before? It's time to do it. These pets are more than property. This is what's happening around the Commonwealth.
There might be a remedy at law if you could establish more on the merits what the content of the agreement was. It's certainly a concern that the court would be drawn into enforcing an agreement that just says 50-50.
In Your Honor,
and particularly at the preliminary injunction stage, where all we have is the defendant's, your client's assertion that we had an agreement that if we split up, we'd share the dog 50-50.
Well, notable in that is that the defendant did not supply an affidavit or anything to controvert our affidavit and our position. And regarding these agreements, which we shared with the Superior Court, they're pretty simple to write. It talks about the time, usually it's alternating weeks, and you can meet, generally it's at meeting at the police station, some neutral ground.
But we don't have such an agreement here.
Well, the
Superior Court judge would have to fill in a lot of details here.
There's a few details which but the fundamental thing is about the right to have an agreement. The agreements can be drafted based in part on what the parties want. Sometimes parties want just for 1 month and 1 month alternating. It can consider what they may have intended, which here, they intended this. They were intended.
If the parties had a specifically phrased and easily enforceable agreement, that would not embroil a court in ongoing supervision of the disputes between the parties, that might be a different matter. Here, at least at the preliminary injunction stage, all we have is an agreement, if we credit the plaintiff's affidavit, that we agreed to split possession 50-50. All the details would need to be filled in either by the judge or by taking more evidence from the parties about what they intended or agreed to, and then the judge would have to find facts.
Or, excuse me, Your Honor, by counsel, by the parties, by the representatives of the parties themselves, which is what we do. You know,
Well, no one's saying that the parties can't come to an agreement and abide by it themselves, and if it becomes specific enough, then perhaps that could be enforced.
So what I'm hearing is if they had put this to a writing, the court would then enforce it, because if it had the specificity, but because it was oral in nature and the Superior Court judge did not give the specificities besides the general 50-50, that it's somehow not enforceable.
At least my point, and I'm not in a position to say today what the law is on this, but it's not the question of whether it's written or oral, but the specificity.
And I think that the specificity is something that's easy to overcome. It's practical, and that's how we are resolving these cases, sometimes in court and outside of court, with these shared visitation, custody agreements. We've tried to find a better word than custody, but we just don't have one right now. Because I just don't understand where it would now leave.
Maybe it's possible, but those aren't the facts in this particular case at this stage of the case. If an agreement is worked out between the parties, then there might be a different set of facts presented for enforcement.
Thank you.
Just let me make sure there are no further questions. Thank you. All right. Thank you, Mr. Cohen. We'll hear from Mr. Bongiorno.
May it please the panel, my name is Philip Bongiorno, law offices of Howard Cahalis. I won't belabor too many points here, but there's too many asks in the appellant's brief. First, they're asking you to find an implied contract, which still requires offer, acceptance, consideration, a meeting of the minds, and at least the material terms of a contract put together. That's not here. All that's here is a agreement that this pet is owned 50-50. There's no determination as to the sharing of it post-breakup, because I don't know of any couple that talks about what they're going to do when they break up.
Well, we have prenuptial agreements.
Well, if you're getting married,
it's not beyond the scope of possibility.
It is not.
That the plaintiff, having had a prior experience with this issue, says at the time they're acquiring the dog, if we should ever split up, I hope we don't, but if we do, my relationship and our relationship with the dog is important, so we'll share possession of the dog 50-50.
Certainly. And that affidavit is presented as evidence, but...
Yeah, and it's not contradicted, so...
Yeah, it's not contradicted, but his own self-serving impressions of what they were going to do post-breakup do not make the terms of the contract here.
Well, they bought the dog, at least according to his affidavit, with that understanding, and then they started to perform that understanding. So let's just assume for purposes of argument that there is an agreement, a contract to share possession of the dog 50-50, if the parties themselves separate. Why isn't it enforceable?
They haven't executed any of the material terms. We don't know who's dropping off who the pet on what day, how long that pet is going to be with the party.
So how much detail, at what point, how do we discern at what point it's enough?
Well, I think
Why is that required? The day of the drop-off, the time of the drop-off, the location? Why is it, other than just we'll share the 50-50?
I apologize.
That's okay.
That's the essence of the custody agreement. That's the entire contract.
Let me give you a hypothetical, and it's actually kind of a real situation. So my mother has 3 sisters. They lost their mother when they were all in their 20s. There was one engagement ring that had value beyond the ring itself. It had sentimental value, and so they agreed between them, each of us gets it for 3 months out of the year. And they dutifully, for many, many years, handed it one to the other to the other. At one point, one of the sisters says, well, I'm just going to keep it. Do you think that the court has no equitable jurisdiction to enforce that agreement?
I think there is a series of facts that would.
No one ever said, well, you'll come to my house in such and such a town on such and such a date. It was just kind of, everybody gets it for a quarter of the year because there's 4 of us and there's only 1 ring.
There might be facts there that would suggest that there is more of a sharing in that situation, but I would also submit that that agreement very well was expected to last in excess of a year and would require a writing under the statute of frauds. We still don't have, there's no writing here. We have an affidavit from the appellant and a accumulation of text messages saying, yeah, you can see him this weekend, which are, in the appellee's opinion, no more than courtesies, and the residual of a post-relationship breakup.
My question clause of the statute of frauds applies to agreements that by their terms cannot be performed in 1 year. I don't see where this agreement, at least on the record before us, cannot be performed in 1 year.
I believe the reasonable interpretation of both parties that this pet was going to live in excess of the year.
Perhaps we also hope so, but we don't know that.
Well, I might not survive tomorrow as well, but they still asked me to execute a contract for my mortgage, my car, and everything else. I would submit that this memorandum or this custody agreement would have had to be put in writing to be even remotely effective.
Let's assume it were in writing, signed by both parties. Is there some reason why specific performance would not be available at the preliminary injunction stage?
Well, if this was a contract in writing with all the material terms and offer and acceptance, then the Superior Court would have the authority to do specific performance. But what the appellant is asking is that we find an implied contract with none of the prerequisites. Then he's asking the Superior Court to input the essential terms, which is what the Superior Court did. They said, sharing Sunday to Sunday, return at noon at a mutually agreeable place. That, in my opinion, is a material term of this type of contract. And then they're asking for specific performance of the contract that the Superior Court wrote.
Can I ask a question that at least I've been missing throughout both of these arguments? We are here to decide whether the single justice abused her discretion. The single justice didn't really get into much about the terms of the contract, etc. What her finding is that the lower court treated the dog as a child as opposed to personal property, and because of that, reversed the decision.
I find no error in the single justice opinion.
Don't you agree that can real property be shared custody? What law prevents that from being done? Both of my colleagues just gave you potentially written contracts where that could be done. Real property could be shared as an agreement between 2 parties. So what did the Superior Court do regarding that? She found there was an agreement. She found that there was an agreement of shared custody. Maybe that's wrong. I'm not saying that that was right, but that's what she found. The single justice didn't really determine whether that was right or wrong. She just said the judge made a custodial decision. Tell me why that's not the case.
Well, I believe there was a previous single justice decision in Lou v. Swank where they determined that they were treating the pet here, which is personal property, as a child. And there's nothing in the legislature that allows the Superior Court to execute custodial arrangements for personal property.
But the lower court made a finding that there was a contract between the 2 parties that said there could be shared custody. Again, we're not here to determine, I don't think, whether that Superior Court judge necessarily made the right decision on that. We have to decide whether the single justice abused her discretion in finding that that was not what the Superior Court judge did, because that's not what the single justice said. She said she's treating this dog as a custodial piece of property.
I would submit that in the equitable remedies, that what the Superior Court did is not something that it has the authority to do.
And that's where I want you to tell me where in the law or where in case, either statutory law or case law, that says a Superior Court judge in equity can't do that. Because that's what I think the gravamen of what the single justice did. She said a Superior Court judge cannot do that in equity. And I'll tell you, I'm having a hard time finding that a Superior Court judge can't do that, but I'm also finding any Superior Court judge does have equitable authority to do that. And if there's neither, I'm not so sure that's an abuse.
I believe it goes back to the issue of the contract, Your Honor. If there wasn't a material term in effect and the Superior Court supplied that term, so not only did it order custody, it ordered custody based upon its own writing of finishing the contract for the parties. So I'm
going to go back to what apparently might be a stupid hypothetical, but I'm going to use it anyway. Two parties buy an antique car. They split up. Ownership of the car is not a question. It was a jointly bought car. Can a judge in equity say, you get the antique car for 1 week, you get the antique car for another week, and you figure out how to get it from one place to another? What law or case law says that a judge in equity cannot do that? We might be making new law here, gentlemen, but you got to give us something that says either you can't or you can, because that's what it comes down to.
I would submit that based on Irwin determining the dog as personal property, that there's nothing here, there's no case law in the Commonwealth to indicate that this pet could not be shared. However, there's a wealth of opinions from courts all over the country that I've cited here that indicate that they're not going to get involved in the custodial sharing of personal property for the mere fact that it's a drain on judicial resources.
Are those cases about the terms of sharing or whether the pet should be shared versus awarded to one party or another along with other property in a divorce? Because as I looked at them, they didn't seem to involve enforcement of an agreement made between the parties.
I believe the cases cited represented both. One was where the court had ordered the sharing, and then due to the issues enforcing the sharing, dissolved the agreement. I believe that
Was that?
I think that was out of Florida, Your Honor.
So then, I don't want to interrupt you if you're still looking.
No, we'll go ahead.
So then if I can, to Justice D'Angelo's question, because I'm not sure I heard the answer. If there's no Massachusetts law on this issue, how can it be an abuse of discretion for the judge in the Superior Court to make a decision that seems to fill the void? I mean, it may be ultimately wrong, or it may be right, but isn't that what discretion's all about? And we have to figure that out down the road.
Certainly, but the trial court is also bound by the precedents of the Commonwealth, and we don't.
And what precedent, again? I thought we just established that there was no precedent directly on point on this particular issue.
Well, again, it's Irwin. Irwin describes it as unusual property, the pet in question, but it does not remove it from the personal property category and remove it to what the plaintiffs are referring to as an equitable sharing agreement.
And is it your position that simply by using the word custody, that the Superior Court judge then, by definition, was treating the pet as a child? Or could there be different interpretations, like custody of a really terrific antique car?
I can't speak to what the Superior Court Justice's mindset was, but the term custody would imply more than a personal property, which I believe the prior justice had equated a dog to table and chairs, unfortunately. And I think that was Justice Lemire's decision in Lou v. Swank.
But do you see a reason why an agreement to share an antique car between two owners couldn't be specifically enforced?
If there was actually an agreement, no, I don't see why that couldn't be enforced. But here, we don't have the terms of the real terms of an agreement to share.
But that's not before us, is it? We're looking solely at what the single justice did as to whether she abused her discretion. It was the trial court judge that made the finding there was a contract here. And that's ultimately what you guys maybe will fight out in the Superior Court. But the single justice of our court said that that's not what the trial judge did. She treated this dog as a person in custody, and therefore she found that that was not valid.
Well, she found that there wasn't going to be a likelihood of success on the merits initially.
Okay. Do you see any distinction between enforcing this agreement for a 50-50 sharing? Do you see a distinction between doing it as a preliminary injunction versus after a trial?
I want to briefly push back on the term. I don't know that the parties agreed to 50-50 sharing.
All right. Understanding that there are facts to be developed, but on the record before us, all we have is the plaintiff's assertion that there was. Mm-hmm. Do you think that's any less enforceable at the preliminary injunction stage than after trial, if that was the agreement that was found to have been concluded between the parties?
Again, there's nothing here that forms any basis of a contract, and I don't believe at the preliminary level that there was the authority to issue any of that. After trial and the judge taking into account the credibility of both parties, there might be a different situation.
So, and I know we're over time, but so your position then is sometimes, as you well know, in the Superior Court right now in a civil case, it could be 4 years down the road before you get a trial. And so you're saying that the judge doesn't have an authority equitably to go and say, that's just not fair, that's not right. So 4 years from now, when we finally get this case to trial and resolve it, then, you know, dog could be here, dog could not be here. It's 4 years later, there's attachments that are formed or lost. Why can't,
I can't
just not
comment
following
on the
Okay.
docket for the...
I'm just talking about the injunction versus waiting for the trial, that a judge doesn't have some authority to say, well, this is why an injunction is appropriate in this particular case.
If there had been more concrete terms and more to rely on, I would perhaps agree. But here, we're talking about, she essentially wrote the contract for her, and I don't believe the single justice erred when she overruled the Superior Court.
Thanks. All right. Thank you very much to both parties for your arguments. That concludes our sitting for today. I want to thank our court